The President must serve in a number of capacities to fulfill a number of duties. Some of these roles are specified in the Constitution, but most of them have evolved over time. The following chart summarizes some of the President's roles. The President is both the head of state and head of government of the United States of America, and Commander-in-Chief of the Armed Forces. Under Article 2 of the Constitution, the President is responsible for the execution and enforcement of the laws created by Congress. 15 executive departments, each led by an appointed member of the President's cabinet, carry out the day-to-day administration of the federal government. They are joined in this by other executive agencies such as the CIA and Environmental Protection Agency, the heads of which are not part of the cabinet, but who are under the full authority of the President. The President also appoints the heads of more than 50 independent federal commissions, such as the Federal Reserve Board or the Securities and Exchange Commission, as well as federal judges, ambassadors, and other federal offices. The Executive Office of the President, EOP, consists of the immediate staff to the President, along with entities such as the Office of Management and Budget and the Office of the United States Trade Representative. The President has the power either to sign legislation into law or to veto bills enacted by Congress, although Congress may override a veto with a two-thirds vote of both houses. The executive branch conducts diplomacy with other nations, and the President has the power to negotiate and sign treaties, which the Senate ratifies. The President can issue executive orders, which direct executive officers or clarify and further existing laws. The President also has the power to extend pardons and clemencies for federal crimes. With these powers come several responsibilities, among them a constitutional requirement to from time to time give to the Congress information of the State of the Union, and recommend to their consideration such measures as he shall judge necessary and expedient. Although the President may fulfill this requirement in any way he or she chooses, Presidents have traditionally given a State of the Union address to a joint session of Congress each January, except in inaugural years, outlining their agenda for the coming year. The Constitution lists only 3 qualifications for the presidency. The President must be at least 35 years of age, be a natural-born citizen, and must have lived in the United States for at least 14 years. And though millions of Americans vote in a presidential election every 4 years, the President is not, in fact, directly elected by the people. Instead, on the first Tuesday after the first Monday in November of every 4th year, the people elect the members of the Electoral College. Apportioned by population to the 50 states, one for each member of their congressional delegation, with the District of Columbia receiving 3 votes, these electors then cast the votes for President. There are currently 538 electors in the Electoral College. President Joseph R. Biden is the 46th President of the United States. He is, however, only the 45th person ever to serve as President. President Grover Cleveland served 2 non-consecutive terms, and thus is recognized as both the 22nd and the 24th President. Today, the President is limited to 2 4-year terms, but until the 22nd Amendment to the Constitution, ratified in 1951, a president could serve an unlimited number of terms. Franklin Delano Roosevelt was elected president 4 times, serving from 1932 until his death in 1945. He is the only president ever to have served more than 2 terms. By tradition, the President and the First Family live in the White House in Washington, D.C., also the location of the President's Oval Office and the offices of his or her senior staff. When the President travels by plane, his or her aircraft is designated Air Force One. The President may also use a Marine Corps helicopter, known as Marine One, while the President is on board. For ground travel, the President uses an armored presidential limousine. Article I, Section 1 of the Constitution vests all lawmaking power in Congress's hands, and Article 1, Section 6, Clause 2 prevents the President, and all other executive branch officers, from simultaneously being a member of Congress. Nevertheless, the modern presidency exerts significant power over legislation, both due to constitutional provisions and historical developments over time. The President's most significant legislative power derives from the Presentment Clause, which gives the President the power to veto any bill passed by Congress. While Congress can override a presidential veto, it requires a two-thirds vote of both houses, which is usually very difficult to achieve except for widely supported bipartisan legislation. The framers of the Constitution feared that Congress would seek to increase its power and enable a tyranny of the majority, so giving the indirectly elected president a veto was viewed as an important check on the legislative power. While George Washington believed the veto should only be used in cases where a bill was unconstitutional, it is now routinely used in cases where presidents have policy disagreements with a bill. The veto, or threat of a veto, has thus evolved to make the modern presidency a central part of the American legislative process. Specifically, under the presentment clause, once a bill has been presented by Congress, the president has three options. Sign the legislation within 10 days, excluding Sundays, the bill becomes law. Veto the legislation within the above time frame and return it to the House of Congress from which it originated, expressing any objections, the bill does not become law, unless both houses of Congress vote to override the veto by a two-thirds vote. Take no action on the legislation within the above time frame, the bill becomes law, as if the President had signed it, unless Congress is adjourned at the time, in which case it does not become law, which is known as a pocket veto. In 1996, Congress attempted to enhance the President's veto power with the Line Item Veto Act. The legislation empowered the President to sign any spending bill into law while simultaneously striking certain spending items within the bill, particularly any new spending, any amount of discretionary spending, or any new limited tax benefit. Congress could then repass that particular item. If the President then vetoed the new legislation, Congress could override the veto by its ordinary means, a two-thirds vote in both houses. In Clinton v. City of New York, 524 U.S. 417, 1998, the U.S. Supreme Court ruled such a legislative alteration of the veto power to be unconstitutional. For most of American history, candidates for president have sought election on the basis of a promised legislative agenda. Article 2, Section 3, Clause 2 requires the President to recommend such measures to Congress which the President deems necessary and expedient. This is done through the constitutionally based State of the Union Address, which usually outlines the President's legislative proposals for the coming year, and through other formal and informal communications with Congress. The President can be involved in crafting legislation by suggesting, requesting, or even insisting that Congress enact laws he believes are needed. Additionally, he can attempt to shape legislation during the legislative process by exerting influence on individual members of Congress. Presidents possess this power because the Constitution is silent about who can write legislation, but the power is limited because only members of Congress can introduce legislation. The President or other officials of the executive branch may draft legislation and then ask senators or representatives to introduce these drafts into Congress. Additionally, the President may attempt to have Congress alter proposed legislation by threatening to veto that legislation unless requested changes are made. Many laws enacted by Congress do not address every possible detail, and either explicitly or implicitly delegate powers of implementation to an appropriate federal agency. As the head of the executive branch, presidents control a vast array of agencies that can issue regulations with little oversight from Congress. In the 20th century, critics charged that too many legislative and budgetary powers that should have belonged to Congress had slid into the hands of presidents. One critic charged that presidents could appoint a virtual army of czars, each wholly unaccountable to Congress yet tasked with spearheading major policy efforts for the White House. Presidents have been criticized for making signing statements when signing congressional legislation about how they understand a bill or plan to execute it. This practice has been criticized by the American Bar Association as unconstitutional. Conservative commentator George Will wrote of an increasingly swollen executive branch and the eclipse of Congress. To allow the government to act quickly in case of a major domestic or international crisis arising when Congress is not in session, the President is empowered by Article 2, Section 3 of the Constitution to call a special session of one or both houses of Congress. Since John Adams first did so in 1797, the President has called the full Congress to convene for a special session on 27 occasions. Harry S. Truman was the most recent to do so in July 1948, known as the Turnip Day Session. In addition, prior to ratification of the 20th Amendment in 1933, which brought forward the date on which Congress convenes from December to January, newly inaugurated presidents would routinely call the Senate to meet to confirm nominations or ratify treaties. In practice, the power has fallen into disuse in the modern era as Congress now formally remains in session year-round, convening pro forma sessions every 3 days even when ostensibly in recess. Correspondingly, the President is authorized to adjourn Congress if the House and Senate cannot agree on the time of adjournment. No president has ever had to exercise this power. Suffice it to say that the President is made the sole repository of the executive powers of the United States, and the powers entrusted to him as well as the duties imposed upon him are awesome indeed. Nixon v. General Services Administration, 433 U.S. 425, 1977, Rehnquist, J., dissenting. The President is head of the executive branch of the federal government and is constitutionally obligated to take care that the laws be faithfully executed. The executive branch has over 4 million employees, including the military. Presidents make political appointments. An incoming president may make up to 4,000 upon taking office, 1,200 of which must be confirmed by the U.S. Senate. Ambassadors, members of the cabinet, and various officers are among the positions filled by presidential appointment with Senate confirmation. The power of a president to fire executive officials has long been a contentious political issue. Generally, a president may remove executive officials at will. However, Congress can curtail and constrain a president's authority to fire commissioners of independent regulatory agencies and certain inferior executive officers by statute. To manage the growing federal bureaucracy, presidents have gradually surrounded themselves with many layers of staff, who were eventually organized into the Executive Office of the President of the United States. Within the Executive Office, the President's innermost layer of aides, and their assistants, are located in the White House office. The President also possesses the power to manage operations of the federal government by issuing various types of directives, such as presidential proclamation and executive orders. When the President is lawfully exercising one of the constitutionally conferred presidential responsibilities, the scope of this power is broad. Even so, these directives are subject to judicial review by U.S. federal courts, which can find them to be unconstitutional. Congress can overturn an executive order through legislation. Article 2, Section 3, Clause 4 requires the President to receive ambassadors. This clause, known as the Reception Clause, has been interpreted to imply that the President possesses broad power over matters of foreign policy, and to provide support for the President's exclusive authority to grant recognition to a foreign government. The Constitution also empowers the President to appoint United States ambassadors, and to propose and chiefly negotiate agreements between the United States and other countries. Such agreements, upon receiving the advice and consent of the U.S. Senate, by a 2/3 majority vote, become binding with the force of federal law. While foreign affairs has always been a significant element of presidential responsibilities, advances in technology since the Constitution's adoption have increased presidential power. Where formerly ambassadors were vested with significant power to independently negotiate on behalf of the United States, presidents now routinely meet directly with leaders of foreign countries. One of the most important of executive powers is the President's role as Commander-in-Chief of the United States Armed Forces. The power to declare war is constitutionally vested in Congress, but the President has ultimate responsibility for the direction and disposition of the military. The exact degree of authority that the Constitution grants to the President as Commander-in-Chief has been the subject of much debate throughout history, with Congress at various times granting the President wide authority and at others attempting to restrict that authority. The framers of the Constitution took care to limit the President's powers regarding the military. Alexander Hamilton explained this in Federalist No. 69. The President is to be Commander-in-Chief of the Army and Navy of the United States. It would amount to nothing more than the supreme command and direction of the military and naval forces, while that the power of the British King extends to the declaring of war and to the raising and regulating of fleets and armies, all of which would appertain to the legislature. In the modern era, pursuant to the War Powers Resolution, Congress must authorize any troop deployments longer than 60 days, although that process relies on triggering mechanisms that have never been employed, rendering it ineffectual. Additionally, Congress provides a check to presidential military power through its control over military spending and regulation. Presidents have historically initiated the process for going to war, but critics have charged that there have been several conflicts in which presidents did not get official declarations, including Theodore Roosevelt's military move into Panama in 1903, the Korean War, the Vietnam War, and the invasions of Grenada in 1983 and Panama in 1989. The amount of military detail handled personally by the president in wartime has varied greatly. George Washington, the first U.S. president, firmly established military subordination under civilian authority. In 1794, Washington used his constitutional powers to assemble 12,000 militia to quell the Whiskey Rebellion, a conflict in western Pennsylvania involving armed farmers and distillers who refused to pay an excise tax on spirits. According to historian Joseph Ellis, this was the first and only time a sitting American president led troops in the field, though James Madison briefly took control of artillery units in defense of Washington, D.C., during the War of 1812. Abraham Lincoln was deeply involved in overall strategy and in day-to-day operations during the American Civil War, 1861 to 1865. Historians have given Lincoln high praise for his strategic sense and his ability to select and encourage commanders such as Ulysses S. Grant. The present-day operational command of the armed forces is delegated to the Department of Defense and is normally exercised through the Secretary of Defense. The chairman of the Joint Chiefs of Staff and the combatant commands assist with the operation as outlined in the presidentially approved Unified Command Plan, UCP. The President has the power to nominate federal judges, including members of the United States Courts of Appeals and the Supreme Court of the United States. However, these nominations require Senate confirmation before they may take office. Securing Senate approval can provide a major obstacle for presidents who wish to orient the federal judiciary toward a particular ideological stance. When nominating judges to U.S. district courts, presidents often respect the long-standing tradition of senatorial courtesy. Presidents may also grant pardons and reprieves. Gerald Ford pardoned Richard Nixon a month after taking office. Presidents often grant pardons shortly before leaving office, like when Bill Clinton pardoned Patty Hearst on his last day in office. This is often controversial. Two doctrines concerning executive power have developed that enable the president to exercise executive power with a degree of autonomy. The first is executive privilege, which allows the president to withhold from disclosure any communications made directly to the president in the performance of executive duties. George Washington first claimed the privilege when Congress requested to see Chief Justice John Jay's notes from an unpopular treaty negotiation with Great Britain. While not enshrined in the Constitution or any other law, Washington's action created the precedent for the privilege. When Nixon tried to use executive privilege as a reason for not turning over subpoenaed evidence to Congress during the Watergate scandal, the Supreme Court ruled in United States v. Nixon, 418 U.S. 683, 1974, that executive privilege did not apply in cases where a president was attempting to avoid criminal prosecution. When Bill Clinton attempted to use executive privilege regarding the Lewinsky scandal, the Supreme Court ruled in Clinton v. Jones, 520 U.S. 681, 1997, that the privilege also could not be used in civil suits. These cases established the legal precedent that executive privilege is valid, although the exact extent of the privilege has yet to be clearly defined. Additionally, Federal courts have allowed this privilege to radiate outward and protect other executive branch employees, but have weakened that protection for those executive branch communications that do not involve the president. The state secrets privilege allows the president and the executive branch to withhold information or documents from discovery in legal proceedings if such release would harm national security. Precedent for the privilege arose early in the 19th century when Thomas Jefferson refused to release military documents in the treason trial of Aaron Burr, and again in Totten v. United States 92 U.S. 105, 1876, when the Supreme Court dismissed a case brought by a former Union spy. 104 However, the privilege was not formally recognized by the U.S. Supreme Court until United States v. Reynolds 345 U.S. 1, 1953, where it was held to be a common law evidentiary privilege. Before the September 11 attacks, use of the privilege had been rare, but increasing in frequency. Since 2001, the government has asserted the privilege in more cases and at earlier stages of the litigation, thus in some instances causing dismissal of the suits before reaching the merits of the claims, as in the Ninth Circuit's ruling in Mohammed v. Jeppesen Data Plan Incorporated. Critics of the privilege claim its use has become a tool for the government to cover up illegal or embarrassing government actions. The degree to which the president personally has absolute immunity from court cases is contested and has been the subject of several Supreme Court decisions. Nixon v. Fitzgerald, 1982, dismissed a civil lawsuit against then former President Richard Nixon based on his official actions. Clinton v. Jones, 1997, decided that a president has no immunity against civil suits for actions taken before becoming president, and ruled that a sexual harassment suit could proceed without delay, even against a sitting president. The 2019 Mueller report on Russian interference in the 2016 presidential election detailed evidence of possible obstruction of justice, but investigators declined to refer Donald Trump for prosecution based on a United States Department of Justice policy against indicting an incumbent president. The report noted that impeachment by Congress was available as a remedy. As of October 2019, a case was pending in the federal courts regarding access to personal tax returns in a criminal case brought against Donald Trump by the New York County District Attorney alleging violations of New York state law. Thank you for watching this video.